There are various fascinating developments which has happened in the polity of India in last week, and in the next few minutes we will try to break them down in various stories so that it will be easy for you to understand. Now, when we talk about polity this week, here we talk about the political developments which has happened in the past week, and we try to address them as per the requirement of our examination for UPSC. So let's start our discussion. My name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In today's discussion, we'll be talking about 4 topics and you can say 4 these big developments which has happened in the country. So starting with the Jammu and Kashmir, we will be seeing that a new government will be formed under Omar Abdullah over there as Chief Minister. So we will be talking about that. We have seen that since 2019, when the status of Jammu and Kashmir has changed from a state to a union territory, after that this is the first time election has happened over here, and now it will be witnessing a new government over there. So that is why it is an important development with respect to Jammu and Kashmir. We will be talking about the powers of the state assembly over here and how it is different from the other states. We will try to compare it with the Delhi as well. Okay. Moving further, we will be talking about the president's rule. Why? Because since Jammu and Kashmir has seen the new government, so officially the president rule there will be ending. Okay. So that is about the president rule. Moving further, we will be talking about the socio-economic and the caste census. When we talk about the socio-economic and caste census, it is an important topic which is discussed in the Indian polity day to day, or otherwise also we have seen that there are elections going on in various states wherein this topic becomes important. Okay, so we will be talking about the socio-economic caste census, as well as we will be talking about the census. Okay, and in the end we will be talking about the bone ossification test in law. Okay, recently there was this assassination which has happened in Maharashtra, that is the killing of MLA Baba Siddiqui, and because of which there was one accused. When it was presented to a magistrate, he has claimed that he is a child, and when he is a child he should be actually prosecuted under the juvenile justice law and not as an adult. That is why this bone ossification test was in news, so we will be talking about that as well. Now coming to the next part wherein we will be discussing the topics. Before that, I have this announcement that we are having GS Foundation courses in offline mode in English medium at our centers, that is Karol Bagh, Jaipur, Lucknow, Prayagraj and Indore. So you can directly visit the center. Admissions are open. You can visit and get enrolled, or you can call on this number, that is 8010440440 for any kind of inquiry. Anyway, moving further, we'll be starting with the Jammu and Kashmir over here. New government in Jammu and Kashmir, revocation of the Jammu and Kashmir's special status in 2019. Now, this is the first heading. Why we are talking about this particular thing is because when we talk about August 2019, to be precise, that is 5th of August 2019, the Parliament has revoked the special status of Jammu and Kashmir under Article 370. And they have actually converted this state into 2 union territories. One is the Union Territory of Jammu and Kashmir and second is Union Territory of Ladakh. It was also said that Jammu and Kashmir will be having a legislative assembly over there on the lines of the assemblies which are there in the Union Territory of Delhi and Puducherry, wherein when we talk about the Union Territory of Ladakh, it will have an administrator which will be appointed by the president, as the case is with the other union territories. Okay. Now, this has happened with the revocation of the 370, or you can say special provision with respect to the Jammu and Kashmir. Here you can say Jammu and Kashmir's special status under Article 370 was revoked and it was converted into 2 union territories, Jammu and Kashmir and Ladakh. Jammu and Kashmir will have a legislative assembly and the Ladakh will not have a legislative assembly. It will have an administrator, which is the case in the other union territories. Okay. Now, coming to this particular provisions, you can say how that provisions got into effect. For that, there was this act, Jammu and Kashmir Reorganization Act 2019. Now, as per that particular act, there was this amendment which was made in the first schedule of our constitution, which is talking about the state and the union territories. We know that when we talk about the state and union territories, they are given, the names are given in the first schedule. Now, since Jammu and Kashmir was earlier a state and now it has to be removed from the name of state and then it was added to the name of union territories, that is why the first schedule was actually amended. After that, governance framework under Article 239, wherein all the union territories administrative provisions are given in the you can say article of our constitution, that is Article 239. Okay, wherein it was given that how union territories will be administered. So two changes were made in the constitution. First was the first schedule and second was under article 239. Okay. Now moving further, here we will be seeing that what will be the governance structure in Jammu and Kashmir. Now since it is a union territory, you know that union territories has you can say special cases wherein it was said that Jammu and Kashmir will have a legislative assembly. So obviously it will have a power to make laws. So where you can make laws, so it was said that Jammu and Kashmir can make laws in the state list. Okay, so in the state list they can go for making any kind of law, but they have exceptions that they cannot make law on public order and police. Okay, so on these two topics in the state list, which is given under the schedule 7 of our constitution, okay, there are three lists which are given. One is your union list wherein union can make the law, then there is state list wherein state can make the law, and then there is a concurrent list wherein both can make a law but the union or the center's law will prevail over there. Okay, so that is given in the schedule 7. In schedule 7 it was said that the state will have a power, legislative power on making law with respect to the state list. Now here it was said that Jammu and Kashmir can make law in the state list, but except for the two topics. One is public order and police. When we talk about the case of Union Territory of Delhi or NCR, when we are talking about this, so in this case it is little bit different, because in Delhi there are three topics on which Delhi's government cannot make law. One is your public order, second is police, and third is land. There are these three topics on which the state government, or you can say government of Union Territory of Delhi, they won't be able to make laws. Okay, in Jammu and Kashmir there are only two topics, public order and the police. Okay, so here you can see Jammu and Kashmir's governance is modeled similar to the territories like union territories like Delhi and Puducherry, wherein they will have a legislative assembly. Okay, but there is a difference. Article 239A, the region will have a legislative assembly like Puducherry. The assembly's power are limited compared to the full-fledged state. Obviously, when we talk about the full-fledged state, all the powers of the legislation under under schedule 7's state list are given to the states. Herein there are certain restrictions which are there. Now power of the legislative assembly. So there is this section 32 of the act which is saying that they can legislate on the subject from the state list but not on the critical matters like public order and the police. Other than that, can legislate on the concurrent list as well, provided there is no conflict with the central law. So Jammu and Kashmir can go for making laws on two topics. One is your state list except for the public order and police. Second is concurrent list, provided that they are not violating any center's law. Okay, so these two things are there. Other than that, there is section 36 which is giving power to lieutenant governor over there, that for any kind of financial bill which is to be present in the legislative assembly, a prior recommendation is needed from the lieutenant governor. Okay, so that is given in the section 36. So this is the structure of governance. These are the power which are given to the state assembly, or you can say union territories assembly. Pardon my use of the word state, because obviously when we talk about the assemblies, they are mostly present in the state. There are only three exceptions with respect to the union territories, that is Delhi, Pondicherry or the Puducherry, or you can say this is your Jammu and Kashmir. Okay. Anyways, moving further, now we will be talking about the role of lieutenant governor. Obviously, when we talk about the you can say union territories, as I told you, there is this administrator which is appointed by the central government or the you can say president in the you can say union territories. So here lieutenant governor will be there. In states we have governor. Here there will be a lieutenant governor. Okay. Now lieutenant governor LG holds significant power under section 53 of the act, which is saying that it can act independently in matters beyond the legislative powers of the state assembly, like All India Service and Anti-Corruption Bureau. Okay, more than the state list, whatever given in the state list, there are certain other you can say areas wherein the lieutenant governor can act with the discretion, that is All India Service and the issues related to the corruption. Then has the authority to make crucial decisions like appointing the advocate general and the law officers. Then we have the LG's decisions are difficult to challenge in the court of law, so ultimately that makes his post even more powerful. His discretion over matters outside the purview of the state legislative assembly, thus influencing the region's governance significantly. So basically here you can see that the lieutenant governor has been given more power in the Jammu and Kashmir Union Territory. Okay, So this is about the Jammu and Kashmir. Herein we will be seeing that there is a new government, and this government in the form of the state assembly, they will be having some limited powers, okay, and there are two restrictions which is their police and the public order. Other than that, we have seen that lieutenant governor has been made more powerful over here. So that is about the Jammu and Kashmir. Now we can move further with the next topic, that is talking about the president's rule. Now you know that when election commission is not ready, or election commission could not go for the election, conduction of the election, so in that case, since there is no government till there at that point of time, so president rule will work over there, okay. So till now in Jammu and Kashmir also president rule was in you can say force, and now since there is a government, that president rule has been removed now, okay. So let's see, we will talk about the president rule. Concept is simple. When we talk about president's rule, that means that there will be a rule of president. That means center will have the more power, parliament will have the legislative powers. So this is what is a president rule. When we talk about president rule, this is given in the article 356, okay, article 356 of the constitution. There is one more article which is attached, that is article 355, that is also being talked about with respect to the, you can say, whenever this president rule is there, or the what are the center's obligation with respect to a state, okay. So that is given under the article 355. Please go through these two articles. Now talking about the president's rule, it is also known as the state emergency or constitutional emergency, okay. Now it is triggered when a state fails to comply with the center's directives, or they are working against the constitution, or you can say the constitutional machinery has broken down, or they are not following the center's directives. In that case, the you can say president can go for the president's rule, okay. Otherwise also president can directly, independently, he can go for the president's rule, or he can base it on a report by the governor of the state, okay. So there can be two you can say cases wherein president's rule can be invoked. One, there is a report from the governor saying that the constitutional machinery of the state has broken down, now you can go for the president rule. So that is one thing. Second thing, if president himself thinks that or herself thinks that there is the constitutional machinery which has broken down, or they are not following the center's directives, in that case also president rule can be there, okay, which is written over here. Now talking about the approval. When we talk about the national emergency, approval has to be taken within the 1 month of the, you can say, proclamation. But in case of state emergency or the president's rule, you have to take the approval within 2 months from the date of the proclamation, okay. So that is there, within 2 months you have to get the approval from the parliament, both house of the parliament, okay. Now for the approval you require a simple majority. In case of national emergency, special majority is required. Here you require a simple majority, okay. So that is given over here. Duration, once the proclamation is made and you can say approval is given, there will be a duration of 6 months, okay. So once after the proclamation, you can say president's rule can be there for the 6 months only, okay, but that can be extended for indefinite, if you can say for 3 years, I guess it can be extended for 3 years, 6 months at a time. So after every, you can say, 6 months you have to take another approval from the parliament, okay. So that is there. Here you can say duration is initially for 6 months, extendable up to 3 years with parliamentary approval every 6 months, and majority is simple majority. I hope that is clear. Now moving further, there are some related articles. So we have seen that article 355 is there, that is saying that it is center's duty to ensure states are adhering to the constitution, okay. That is one thing. Other than that also there is one duty that central government has to ensure that states are safe, okay. The safety of the states has to be ensured by the central government, okay. So that is also there. So it is center's duty, it is an obligation which is made on the center, okay. Coming to the second part, that is article 356, that is empowering the president to declare a president's rule if the state's governance is not according to the constitution. So now one thing is that clear, that it is center's duty to make sure that everything is working according to the constitution, okay. If it is not, then center can give some kind of, now center has given the directives but state is not following. In that case president has the power. Now first it is duty, but that if that duty is not fulfilled somehow, then president has power to go for imposing the president's rule, okay. To extend beyond 1 year, 2 conditions must be met. We have seen that 6 months will be there after the proclamation. Then if you go for the parliamentary approval for the next 6 months, again you can go for it. Then after 1 year, if you have to go for the president's rule, okay, then there should be two conditions. One is that national emergency must be in effect in any part of the country or the whole country or in the state. Okay, so if there is a national emergency which is there in the whole country or the part of the country or the state, in that case you can go for the extension of the president's rule. That is one condition. Second condition is election commission must certify that they are unable to conduct the election within the stipulated period of time. That is why for that period there will be a president's rule. Okay, that was the case in Jammu and Kashmir. Since election commission was not able to conduct the elections, that is why it was under the president's rule. Okay, coming to the next one, revocation. President do not require any kind of approval for the revocation of the, you can say, president's rule. He can directly go for the you can say revocation by an order. Second thing is, this particular you can say if president is not revoking it, okay, and the parliament has not approved it, it will automatically stop to be in the force. Okay, so that is clear. Now moving further, what are the impacts of the president's rule? So obviously power will come to the center, and who is the lawmaking authority at the center? That is parliament. So parliament will assume the role of the state legislature. They will start to make the law with respect to the state list as well. Okay, then state council of minister is dismissed. Moving further, state legislative assembly can be suspended or dissolved. Okay, law made during this period remain in force even after the president's rule ended. Okay, so during the president's rule, if parliament has made a law, that will be valid after that as well. Okay, then there is no impact on the fundamental right. Now with the president, when we talk about the national emergency, you will see that fundamental rights are also getting impacted. Okay, so there are two ways. One is when we talk about the you can say war and external aggression. In that case, article 19, that will automatically be suspended. After that, for other, you can say, fundamental rights, president can issue an order. Okay, and right under article 20 and 21 will not be, you can say there is no curtailment you can put on these you can say articles, that is article 20 and 21. Okay, so these two fundamental rights will not be impacted. This will start to get impacted automatically, and there is a president's order in which he can mention that whichever fundamental rights are not enforceable anymore. Okay, so that is the case in the national emergency. So here you can see in the national emergency, fundamental rights are getting impacted. But when we are talking about the president's rule or the state emergency, in that case, government of the state is getting impacted and not the fundamental rights. Okay, so that is an important point which you have to remember. So we have talked about the Jammu and Kashmir's new government. We have talked about the president's rule as well. Now we can move further to the next topic, that is talking about the socio-economic caste census. Census is simple. You have to take into consideration the number of the people. There are various data which you have to collect, and that will be, you can say, presented or you can say analyzed by the government, and then they will present in the you can say public domain. Okay, so that is the census. When we talk about census in India, it is happening every decade. Okay, so last census was in 2011, that is 2011. Next was due in 2021, but because of the COVID, it was postponed, and the Home Ministry has said that they will be conducting the census soon. Okay, anyways, in 2011, socio-economic caste census data was gathered, but since the quality of data was poor, that was not made public. Okay, so that is there. Now coming to the socio-economic caste census. What is socio-economic caste census? Obviously, with the name itself, it is clear that here you are taking cognizance of the social as well as the economic conditions as well. Okay, so let's see. Census, if we talk about, so it started way back in 1881 during the colonial era. Okay, though this exercise was not very, you can say, holistic in nature. Okay, so that was their purpose, was to capture the population, resources, social changes, and help in the delimitation. Then criticism was considered a blunt instrument and not suitable for the specialized inquiries. Okay, so as I told you that the quality of data was not very good in the first census. Okay, but it was happened in the colonial time in 1881. After that, there are census which are periodically happening. Okay, coming to the socio-economic caste census. So here you can say this was first time conducted in 1931. Okay, then it was stopped when we are talking about after independence. It was stopped, I guess, in 1951. But now recently there was this demand by various states that you have to go for the socio-economic caste census. Okay, Now purpose is to collect economic data of the household caste name to identify deprivation indicators and evaluate economic condition of the different caste group. Now you are taking the economic data, you are taking the caste related data, and you are trying to analyze that which caste is having, you can say, some kind of disparities, or you can say which are lagging behind. That is depending on this particular data, that is socio-economic caste census. When we talk about the reservation, it is generally said that you need to have a quantifiable data to prove that the particular, you can say, section is underrepresented. So how will you do that? For that you need to have a, you can say, data. That data can be you can say socio-economic caste census. Okay, so that is why states are, because of the reservation policies etc., states are actually asking for the socio-economic caste census. Okay, obviously there are positives and negatives which we will be talking about later. Now here you can see difference between the census and the caste census. So when we talk about census, it provides a general population portrait. Data is confidential under the Census Act 1948. When we talk about the census, whatever data is gathered, okay, you see that we are having the analyzed data, that we have the literacy rate, we have the you can say how many people are there with respect to you can say number of the people in the country. We know what is the percentage of rise in the population. All these things are there. This is the analyzed data. The original data of a particular household which has been gathered from a household, that is not made public, because there is this confidentiality clause which is given in the act. Okay, so you cannot share that data publicly. Only thing is you can only share the analyzed data. Okay, now that is the case with respect to the census, that is talking about the population or the demographic data. Okay, coming to the SECC, that is socio-economic caste census, it identifies the beneficiary for the state support. Data is open to the government department. Now socio-economic caste census is telling you that which section is lagging behind. Okay, and now if you are making a scheme for this particular section, then you have to go through that particular data. So that data is open for the government department. Okay, so that confidentiality clause is not working in the socio-economic caste census. Now coming to the history of the caste based data collection. So as I told you, until 1931 caste based data was collected. Then after starting from the 1931 this data was collected. Then 1951 the caste data collection stopped to avoid the divisive approaches. Now since you are collecting the data, you are saying that this particular caste or this particular section is lagging behind, this section is well to do, then you are basically creating a gap, you are creating a class of people. So that is why there can be a divisive politics around that particular you can say data. That is why they have stopped the caste data collection. Okay, now there are these demands that should be renewed. Okay, so that is there. Now let's see what are the, you can say, significance of the caste census and what are the negatives. Here you can see it addresses the social inequality. Now if you want to go for any kind of you can say scheme for a particular section, okay, to reduce the inequality, for that you need to have such data. Okay, so that is one thing. Equitable resource distribution. Now you know that one section of the society is not doing very well economically, so you want to redistribute the data, the resources among these particular sections. So for that also this is important, equitable resources distribution. Okay, so for that we have this affirmative action etc. Okay, so for monitoring the affirmative action also we need to have this particular caste census, because the courts has again and again has said that you need to have a quantifiable data to go for any kind of affirmative action or the reservation for per se. So for that also we need to have this data. Moving further, comprehensive picture of the society. It gives a picture of the society saying that who is doing well and who is not. Okay, who is being exploited and who is not. So that is the comprehensive picture which is given by this particular data. Then constitutional mandate, we have Article 340 which supports the investigation into the condition of socially and the educationally backward classes. Okay, so you know that there are various commissions which are there with respect to the, you can say, socially and educationally backward classes under Article 340. Okay, so that is the constitutional mandate. Coming to the arguments against the caste census, one is reinforces the caste system. If you are going for collecting a data on the basis of caste system and then you are analyzing the data and you are saying that this caste is doing well and this caste is not doing well, so ultimately you are creating a, you can say, unequal society. You are reinforcing the caste system again. Okay, then defining the caste, again this is problem. When we talk about the defining the caste, that is problem, because Indian society is so divided on various lines, various we have religion, then we have various sects. When we are talking about the caste, there is no dearth of the caste. Okay, everyone is having a different story of their own caste. Okay, so ultimately you will not be able to define. Okay, so that is there. And then exhibits the social division, which we have already discussed. Okay, now what is the government stand? So in 2021 the government decided not to enumerate caste wise population except for the SC and ST in the census. So they have said that since they have gone for the collection of the data in 2011 and the quality of data was not very good, so they did not actually release the data. Okay, so similarly in the 2021 census they have said that they will not be going for collecting the data for the caste except for the SC and STs. Okay, so that is the government stand as of now, but there are various state governments which are asking for it. Okay, so that is about the caste census and the data. Now moving further, we'll be talking about the bone ossification test. As I told you that there was this you can say assassination which has happened, and after that there are various accused. Okay, one among them is saying that he is a child and he should be tried under the Juvenile Justice Act. Okay, why? Because under the Juvenile Justice Act there are provisions which are, you can say, made for a child. These provisions are lenient in nature. These are not punitive actions. These are basically trying to, you can say that it is corrective actions which are present in the Juvenile Justice Act. Because of which their issue went to the court, and he said that he is a child and his Aadhaar card was saying that he is not. Aadhaar card was saying it was that person is of 19 years age, but again he has claimed that he is a child, and that is why court has gone for the bone ossification test. Bone ossification test is basically, you can say, a tool wherein you can determine the age of a particular person, that will give you a bracket of the age. Okay, so the test was done and it was the result was saying that he is a adult and he will be tried accordingly. Okay, now let's see what is the test, what is the provision in the law with respect to this particular test. So the bone ossification test serve as a critical tool in age determination when documentary evidence is unavailable, helping courts decide how to apply the law appropriately. Okay, here it is clear that when documentary evidence is unavailable, first courts will rely on the documentary, you can say whatever you have, your 10th mark sheet, your birth certificate, etc. If you do not have that, then there are other methods. The bone ossification test is the last resort. Okay, so that is there. Now ossification. Ossification is the process of bone formation. From the time you are in the womb of your mother, the bone formation starts, and till your adolescence, okay, is of 14, 15, sometimes 18 also, this bone formation keeps on happening. Okay, so you will be seeing that till the age of 14, 15, even 18, 19, your height might, you can say, increase. After that, that will not. Okay, so that process of bone formation, that is basically called as the ossification. Okay, so natural process of bone formation is starting in the fetal stage and continuing through the adolescence. Okay, now test process. So they will go for the X-ray of various bones like your hand, the wrist, etc. They will be going for the X-ray, and there is a standard X-ray which is there. So they will actually compare it with that, and then they will decide what is your age. Okay, so see, X-ray of the specific bones, that is hand, wrist, etc. are taken to assess the skeleton development. Okay, now skeleton development can happen at a different pace for different individuals. So for individual to individual it can be different. Okay, now coming to the comparison, if you talk about, the results are compared with the standardized age based bone maturation data to estimate the person's age. Okay, so there is already a data which is there, that is the standard data with which you will compare the X-ray, and then you will decide what is the age. Okay, ossification test give you a bracket, like that will say that from 16 to 18 years of age, or you can say that this person is having age of 17 to 19. Okay, generally in these cases the court will take the upper age and they will have a bracket of 2 years. They will consider the bracket of 2 years. Okay, so that is there with respect to the bone ossification test. Now coming to the importance in the law. When we talk about the law, Juvenile Justice Act is saying that a person is minor who is less than the 18 years of age. Okay, and in some heinous crimes, so they are having this scope of 16 to 18 years. Here you can see a child below the age of 18 is considered as minor. However, the act allows for the special provision for children aged 16 to 18 who are involved in the heinous offenses. Okay, if there is a rape, murder, etc., in that case they will go for the 16 to 18 and they will try to see that what is the mental status of that particular person. Okay, anyways, juvenile accused of crimes are presented before the Juvenile Justice Board instead of a regular criminal court. So they will not be presented in the criminal court, they will be presented in the Juvenile Justice Board. Now the Juvenile Justice Board will go for the investigation, inquiry, all these things, and then they will come up with the judgment. Okay, Juvenile Justice Board will be comprising of a judicial magistrate. There will be one magistrate and two social workers. Okay, so that will be the board and they will decide. The board is responsible for ensuring the juvenile receives a proper legal and the psychological assistance. They will also go for the psychological assistance. The idea behind this is that the child feel comfortable. See, children are having this cognitive development which is happening. Now if you put them inside the normal jail, then there are, you can say, people who has committed heinous crimes. There are people who are having a criminal mindset. You cannot just put these kids in the jail with them. Okay, there are high chances they can be exploited. There can be, you can say, some kind of you can say issues with you can say these kids in the jail, and for that we have this Juvenile Justice Act. Okay, now the JJB or the Juvenile Justice Board conducts inquiries and makes decision regarding the treatment, rehabilitation and the reintegration based on the child's background and the nature of the offense. Okay, on the basis of the offense, on the basis of the background of the child, they will decide that how, you can say, corrective action can be taken. So this is about the law. Now talking about certain specific provisions which are with respect to the Board ossification test. Okay, so there is this section 94 of the Juvenile Justice Act. See, before going into that, I would like to tell you that when Juvenile Justice Board is looking at a person, okay, and that person, by the look of it, by prima facie, it is seen that that person is not juvenile or juvenile. Okay, in that case, let's say if a kid has committed a crime, he is of 3 to 4 years of age, it is clear that he is a juvenile. If a person who has committed a crime and he is of 45 years of age, it is clear that he is a adult. Okay, but in the area wherein the age is 15 to 19 or 20, in this case there can be confusion. Only then Juvenile Justice Board will go for the affirmation of the age, confirmation of the age first, and then they will go for the inquiries. Okay, so let's see. It prescribes a documentary evidence, birth certificate, school record as the primary age determination method. Ossification is used only in the absence of the document. Now if you have to go for the confirmation, how will you confirm? First you have the document. If it is there and it is a substantial evidence that this person is adult or juvenile, that's fine, the board will rely on that. But if it is not sufficient evidence, in case of Aadhaar card, in this particular case, if someone is saying that the Aadhaar card is fake or someone else has made the Aadhaar card, in such cases you can say that they will go one step further. Okay, court stands the test cannot override the valid documentary evidence. Here the key point is the valid documentary evidence. Okay, now courts have occasionally rejected the request for the test when reliable documents was available. If there is a reliable document, court will not go for the test, but if there is some kind of issue, some kind of confusion, that is the last resort. Now reliability and the challenges. So in this particular test there are some challenges, because when we are talking about the development or the skeleton developmental process, in that basically it depends on the individual to individual. Okay, so there can be a scope of variation, there can be a scope of error in the test. Okay, so variability, the individual difference in the bone maturation can affect the accuracy, with the results often providing a range that is 17 to 19 years. Okay, so that is one thing. Court interpretation, if we talk about, so courts sometimes accept the upper limit of the test range for the legal decisions, especially in the sensitive case like POXO, etc. So we have seen that if there is a range, let's say the test is saying that this person is 17 to 19. Okay, so in that case they will, you can say, rely on the 19 years. Okay, so that is about the Juvenile Justice Act and the ossification test. Okay, now there are certain questions which are there which you have to attempt. So let's see. Which article ensures the duty of the central government to ensure compliance with the constitutional provision in the states? Article 356, 370, 365 and 355. Okay, so you can attempt these questions and answer to me in the comment box. Second question over here is that when was the first SECC conducted in India? 1931, 1951, 2001 and 2011. Okay, Moving further, question number 3. Which provision restrict the Jammu and Kashmir Legislative Assembly from legislating on public order and the police matters? Article 239A of the Indian Constitution, Jammu and Kashmir Reorganization Act 2019, Article 370, first schedule of the Indian Constitution. Okay. Now moving further, a last question is that which age group of the juvenile may be tried as the adult under the Juvenile Justice Act in case of heinous offences below 12 years, 7 to 12 years, 16 to 18 years or above 18 years. Okay. So you have to attempt these questions and answer to me in the comment box. With that, I would like to take your leave. I'll see you in the next episode. Till then, have a good day. Thank you and please subscribe the channel.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.